Good afternoon, everybody. I hope everyone had a great weekend this past weekend. And thanks for joining us for our third Notary Town Hall of 2024. Today, we're going to talk about the different allowable actions that a notary public may perform. So we're going to cover what each of them are, excuse me, and then how they work, and then talk a little bit about the certificates for each one of those, the notarial certificates. During the town hall today, I asked everybody to make sure they're muted so we're not getting any background noise or feedback. Feel free to keep the cameras on if you like. I love to see the smiling faces, but those microphones. If anybody's not been on Google Meet before, there's a little chat feature you can use on the left or on the towards the bottom right-hand side of your screen. If you have any questions as the town hall goes on, feel free to throw them in there. We'll have a notary officer keeping an eye on that chat box and trying to answer them as they go. Ask that you try to keep those questions more on topic as well. If you have a general notary question that's unrelated to this town hall, reach out to us at the Notary Division's email address, dlnotary_sos@maryland.gov. That contact information page, I'll have it up at the end of the town hall. So if you didn't catch that, DL Notary, like distribution list, notary_sos@maryland.gov. Reach out to us there. We want to try to keep the chat box and the questions and answers that we'll deal with at the end here, related to the topic we're discussing here. If you have any notary questions between town halls, please reach out to us. Again, the contact information, I'll have it on the last slide here. We'll have the phone number and the email address for the Notary Division. Reach out to us, ask us the questions, and whenever you have them. You don't have to wait till the town hall to jump on and ask. You can ask us at any time. We want to help you as much as we can and get any questions you have answered. So feel free to reach out to us at any time. And I'll run real through to the phone number again here for a minute. Main office phone number, 5521. Let them know you have a notary question. Email address, dlnotary_sos@maryland.gov. And that way, you can get any question you have answered. Today's town hall is being recorded. By participating in the town hall, you're consenting to the recording. And this recording will get posted on the notary page of our website, usually within a week or so of the town hall, often sooner, but usually within a week of today. The recording from this town hall will be posted. So if you miss anything, you want to go back and look at it again in the future, it'll be there along with the rest of our town halls on the main Notary Division page of our website. So again, today's town hall is being recorded. By participating, you're consenting to the recording. Also, important to note that recording and PowerPoint presentation here is provided for informational purposes only. It is not intended to be legal advice. It is not intended to be legal advice. So some folks will reach out to us and ask us as well, does this town hall, do I have to take this? No, this is an outreach effort by our office to try to communicate directly with notaries that are interested about different topics, different things that come up, different things we get asked about on a regular basis. So this is just that outreach effort. This is not a substitute for the required course of study for those of you that are renewing, and the required course of study exam for those that are looking to apply to become a notary or become a notary again. This is not that course of study. The course of study covers a wide range of topics in notary law, and it would not, this doesn't do that. This is about a specific area of interest today, which is the allowable actions and notarial certificates. So all that said, welcome. Thanks for joining us. Again, as you go along, feel free to throw a question in the chat box. We'll try to answer it there. We may not answer it there. We may save it to the end. And after all this is said and done, we'll save a little time for questions and answers that folks may have, and we'll take care of that at the end. And if there's a little hand raising feature as well, if you think of a question and you wanna get called on later, go ahead and hit that little hand raising feature in the Google Meet. Again, you may find your questions are answered as we go. So hang tight, and hopefully this is informative here. So let's get started. The way we start every one of these town halls, right? Sources of legal authority, Maryland Constitution, Annotated Code of Maryland regulations, different sections of the law. There are Title 18, Subtitle 1, Title 18, 2 of the state government article of the Annotated Code of Maryland, and then the Code of Maryland regulations, 0102, 08, 01 through 17. And so here we go. Useful links. Just want to throw this up towards the beginning. Just kind of a general thing about notary information. We often get questions from folks all the time. Sometimes here on the town halls in the chat box, which actually remind me to say, if you throw a question in the chat box, great, but don't answer anybody's question in the chat box. Let our notary officers answer those questions. We don't want any folks to be confused about what is or isn't the right answer. We've had some well-intentioned folks over the years answer questions incorrectly in that chat box. And with that in mind, this page here, just take a quick look at the information here. The main notary division page on our website, sos.maryland.gov. Then the /notary page is default. But if you just remember sos.maryland.gov, you can click on the notary tab at the top of the page. That'll take you to that main notary division homepage, from which you'll find a lot of information you want to know about being a notary. You can find where to order the handbook there. There's the link directly. You can find links directly to the section of Maryland law, or to where you can search sections of Maryland law. You'll find the summary page about how to apply to become a notary, or how to renew your notary commission. You'll also find frequently asked questions page. So a lot of good information at that sos.maryland.gov /notary /pages, etc. Folks will often start a question with, I was reading online, and our first question is usually, where online? And so make sure you're checking known and reputable sources, namely ourselves, right? We're the ones that'll regulate this stuff, and if something happens or goes wrong, we'll be the ones that talk to you about whatever it is you did or didn't do as a notary. So refer to our pages. Don't take anybody's word for it online or in some chat forum. You may not even be talking to somebody from Maryland in that forum, and notary laws are very similar, but a little different in different states. So we want to make sure you're looking at the right stuff to help you understand what it is you're doing. This right here is a good place to do that. So these links here, again, the recording will get posted. So if you're missing these, don't panic if you haven't written them all down yet. If you go to that first page, sos.maryland.gov /notary /pages /default.aspx, that first link, every one of these pages can be found from that first page. So that's really the place you want to start your notary search with, right there, and it'll take you to some of the information you want to know, where you can find it from that notary landing page. So why we're here today: types of notarizations, general powers, identifying signers, authority. So just a couple different things, a little housekeeping up front here. In-person notarizations. So your traditional notarial act, somebody comes before you in person, standing in the room with you, and you're going to identify them and watch them sign the document and complete whatever the notarial certificate is and affix your seal and make an entry in your register of official acts, now more commonly referred to as the journal. And there's nothing special. This is what you do every day as a notary, probably. You're notarizing in person. So physical presence, you need to be there together. Things are happening at the same time. The notarization and the completion of the notarial certificate, the creation of the journal entry, the affixing of the notary seal on the record that's being notarized, all that's occurring contemporaneously. That's all happening at the same time and occurrence. The notarial act is happening. When you notarize something now, it's not, oh, hey, I saw you sign it, and I'll just go notarize it at some point in the future. The notarial act, it needs to all occur at the same happening in time. You identify them, you watch them sign, you complete the certificate, you make the entry in your journal, you affix your seal and all to that document that's being notarized. You're there together the entire time. And that's all happening at the same time and place. You're going to notice, by the way, these 5 steps, we repeat a lot. We're going to repeat a lot for most types of notarial acts. A few other things about in-person notarizations. Folks always ask us about fees. Always ask us about fees, and in particular, if they have to travel somewhere. So we talked a lot about fees in our last town hall. It's $8 for a regular notarial act, $30 for a remote notarial act. There are travel fees that you can charge. You can charge $5 because you had to go somewhere, plus you can charge mileage. So if you were to travel for a notarial act, and there's a good breakdown in our last town hall, there's a slide that just covers a scenario in which a notary is asked to travel to notarize. And it does the math, $5 because you had to go somewhere, plus the mileage, plus the $8 per notarial act. Folks will oftentimes refer to themselves as a mobile notary. I'm hoping that's just because it means they're willing to travel to notarize. Mobile notary is not a separate licensing category. It's not a legal status. It's not an actual thing. It's a term people use. You won't find mobile notary anywhere in the law. A lot of folks that are mobile notaries will often provide services that are more in line with a title insurance producer, where they might notarize something, but they're a title insurance producer for a loan signing agent or a closing officer, or various things related to the sale of real estate that people refer to themselves as. But in terms of the law, mobile notary is not an actual thing. People that travel refer to themselves as mobile notaries, but if you're only acting as a notary, you're only allowed to charge the fees that a notary is allowed to charge. We're not going to make this whole town hall about those fees, but the last town hall we did has a lot of good information about those and really breaks that down, as well as that frequently asked questions page that I referenced up here in the prior slide. The bottom here, if you go to the notary landing page, you'll be able to find frequently asked questions. There's a question somewhere in that list about the fees you can charge, and so it's up to date with the most recent charges that you're allowed to make. And reiterate, I shouldn't say reiterate, but reiterate from last town hall to this one, you're allowed to demand and receive up to those amounts. You can't demand more than those maximum amounts, and you can't receive more than those maximum amounts. No matter what type of fee you want to call it, after hours, convenience, tip, whatever, can't do any of that. The fee is the fee is the fee. You can charge up to that amount, but no more. Can't demand more than it, can't receive more than it. Those fees are the maximum amounts. So another type of notarial act, electronic notarization. This is the electronic signature and electronic seal, but you're in person. So it's still in person, but it's an electronic document with electronic signatures and electronic seals. I'm still sitting in the same room as you. I'm still watching you affix your signature. All that's still the same, except for this stuff is happening on an electronic medium rather than a tangible record. And there's not a separate licensing category for e-notaries that they're sometimes refer to themselves as. So you're just a notary that does electronic notarizations. It's not a special licensing category. Remote notarizations, legal in Maryland, effective October 1st, 2020. So a little different than electronic notarizations. Remote notarizations, the signer appears before the notary at the time of the notarization using specifically designed and approved audiovisual technologies. The person signing the document will sign the document electronically. A remote notary technology allows the notary to witness the signature and allows them to simultaneously affix their seal on the notarial act. And it's all an electronic record. And gets called various things. You'll see some of the terms there, but regardless of the nomenclature used, Similar to an in-person transaction, that entire notarial act is occurring in the same time and place. It's just virtual instead of in person. There is a remote notarization for tangible record that's allowed now as well. We'll have a remote notary town hall later this year. And if anybody's interested in learning more about remote notarizations in the meantime, we had a remote notarization town hall late in 2023, and that recording is also on the Notary page of our web, so you can get a lot of information there about remote notarial acts. But regardless of whether you're in person or remote or electronic in person, whatever it is, you're only allowed to perform certain types of notarial acts. You can take an acknowledgement of a record, verification, oath, or affirmation, witness or attest a signature, certify or attest a copy of a record or an item that was copied, certify that a tangible copy of an electronic record is an accurate copy of that electronic record, and make or note a protest of a negotiable instrument. We're going to talk about all these notarial acts in a little more detail here throughout this presentation. So authority of the notary, quickly here, you can notarize in any county in the state, any county in the state, or in the city of Baltimore, regardless of where you're commissioned. So what does this mean? Let's say I'm commissioned in Anne Arundel County. I can still notarize in anywhere in Maryland. As long as I'm standing in Maryland, when I'm notarizing, I'm allowed to notarize, regardless of where I'm commissioned. If I'm on vacation down at the ocean, down in Ocean City, I could notarize. I'm an Anne Arundel County notary, but I'm standing in Maryland when I'm notarizing, so I'm okay. I could go up to the mountains, north, south, east, west. As long as you're standing in the physical confines of the state of Maryland, you can act as a Maryland notary, regardless of the county in which you are commissioned. And a notary can notarize documents to or from another state, as long as you're standing in Maryland while you're notarizing it. So it's where are you, not where the document's coming from or going to, and not where the person's from originally or going to. You're here in Maryland. That is where your authority as a Maryland notary rests. If you want to be a notary in another state, go apply to be a notary in that state. If you want to notarize there, there's not reciprocity with that. Somebody usually asks that question. There's no reciprocity. If you want to notarize while you're standing in DC or Virginia or Pennsylvania, Delaware, wherever it is, you need to go to that state's notary office and get commissioned in that state. So a few other points of housekeeping here: conflicts of interest. Can't perform a notarial act with respect to a record to which the notary or the spouse of the notary is a party, or in which either the notary or their spouse has a direct beneficial interest. While the law prevents a notary from performing a notarial act in which the notary or their spouse has a direct beneficial interest, a notary should also refrain from performing acts for any member of your family and any matter in which the notary is personally involved, even if indirectly, in no beneficial interest. You're an independent party to the transaction. Your job as a notary is to not be a party to the transaction or involved, and to avoid that conflict so you can be an indifferent party that can make sure the people are who they say they are, and make sure they're the correct persons that are signing that document that you are going to ultimately notarize. And really any of your immediate family members you should not notarize from. There's 80,000-ish notaries in the state of Maryland. You can find a different one than yourself to notarize for family. So again, you're not under the legal duty to refrain unless it's yourself or your spouse or a direct beneficial interest. But stay away from family notarizations. That's the best thing. Everything's good until it's not. And in a prior life here, I dealt with notary complaints, and a good chunk of them, I couldn't tell you the exact percentage, but a good chunk of them, and probably even the majority of them, dealt with a notarized document that was being disputed by family members. And when the notary is also a family member, that just makes it even more difficult. And again, don't if you don't have to, but you cannot for yourself or your spouse. A few other restrictions here. Can't assist somebody in drafting legal records, can't give legal advice or otherwise practice law. Unless, of course, you're also an attorney, in which case you're going to be doing that as an attorney, not as a notary public, right? Cannot act as an immigration consultant or expert on immigration matters. If you're a notary, you can't Pretend to be an immigration consultant or expert. Got a license in that field? Sure, great. But you'd be doing it in that capacity, not as a notary public. Can't represent people in judicial proceedings, can't receive compensation, can't falsely or deceptively advertise, can't refer to yourself as a notario or notario publico. In many Spanish-speaking places here in the Americas, notario is also an attorney. You don't want to be misleading people that you're an attorney. You are not. You are a notary, unless you are separately licensed by the Bar of Maryland and an attorney, in which case, great, you're also an attorney. But as a notary public alone, you can't go give legal advice, practice law, be an immigration consultant simply because you have a notary seal. Those are separate things and separate hats that you should wear separately, and be clear about that. Don't confuse being a notary with being those things. So notarial certificates and these specific types of notarial acts that you can perform, you know, the 6 again here: acknowledgments, verification, oath or affirmation, witness or attest, certify or attest a copy of a record, certify a tangible copy of an electronic record, protest of a negotiable instrument. We're going to cover each of these in some detail here. But first, a very important thing, and still probably one of the most confused things that notaries face, especially notaries that have been notaries for a long time. So on October 1st, 2020, there's significant changes to the notary law. And we talk to people on a pretty regular basis. A very common refrain is, you know, I've been a notary for forever, for years. And yes, but notary law is a lot different than it was years ago. In October of 2020, the new law took effect. And it changed a lot of things, or made certain things more formal, or required more information about certain things. One of the things that changed in the law in October of 2020 is the requirement that every notarial act must include a notarial certificate. If you do not have a notarial certificate on that notarial act, it is not a notarial act. In order to complete a notarial act, there must be a notarial certificate. Every notarial act. Prior to October 1st, 2020, if you were just witnessing a signature, you date, sign, seal, my commission expires, move on. Not anymore. Not anymore. Every notarial act must be evidenced by a notarial certificate. So a notarial certificate is really a story of what is happening at the time of that notarial act. Where are you? Who came before you? When did they come before you? What's being notarized? So there is information in the notarial certificate that you're completing, and we're going to talk about these certificates here for a few. But there's a different type of notarial certificate for various types of the act. So if you're doing an acknowledgement, your certificate is different than a verification, oath or affirmation, or an official witness, or attesting a signature. Each certificate for each type of act. There's an example in the handbook of like a baseline certificate for every type of notarial act. Does every certificate have to look exactly like the one in the law and in the handbooks? No. But that's a good baseline for what it should look like, or what it should at least contain. So each certificate, on every notarial act you perform, there should be that certificate. That certificate shall be executed contemporaneously with the performance of the notarial act. You heard me mention that word earlier. It's happening at the same time and place as the notarial act. Signed and dated by the notary public. The signature should be signed in the same manner as on file with the clerk of the circuit court. It should identify the jurisdiction which the notarial act is performed. One of the biggest misconceptions about the notarial certificate. Folks will write state of Maryland, county of. The county that should go there in the certificate is where you are at the time and place of the notarization. Now, earlier I gave that example of being commissioned in Anne Arundel County, but maybe I'm down Ocean City and I'm notarizing something. That certificate should say state of Maryland, county of Worcester. Should not say Anne Arundel County in the certificate. My seal is going to say Anne Arundel County because that's where I'm commissioned. but that certificate is telling the story of what's happening at the time of the notarial act. And if I'm in Ocean City, I'm not in Anne Arundel County. So state of Maryland, county of, wherever you are at the time of the notarial act. And if it's Baltimore City, you would write Baltimore City instead of Baltimore County. Baltimore County and Baltimore City, two different jurisdictions. To many of you, that may sound kind of goofy that I'm saying that, but you'd be amazed how many times we see notary seals that say Baltimore City County, Baltimore County City. They're two different jurisdictions. So if you're Baltimore City or City of Baltimore or Baltimore County, they're different places, one or the other, but not both. And your notary seal should have the jurisdiction in which you were commissioned. So making sure that when you're writing your certificate, it's not worried about where you're commissioned, it's worrying about where you're at the time of the notarial act. And when it says state of blank, that blank should always say Maryland. Why? Because if you're a Maryland notary, you can only notarize in Maryland. So you should always be standing in Maryland when you're acting as a notary. So state of Maryland, always, county of blank, wherever you're at, or city of Baltimore if it's Baltimore City instead of Baltimore County. The certificate shall contain the title of the office of the notarial officer. So in your case, it's notary public. And if the notarial officer is a notary public, indicate the date of expiration of the notarial officer's commission. So every notary public has an expiration date. The way the law was worded, other certain officials can be a notary, but in your case, we're talking about the notary public. So you're going to have your expiration date as part of that notary commission, or it could be part of your seal, or both. Notary public may not affix their signature to or logically associated with the certificate until the notarial act has been performed. So you've identified the person, you've watched them sign the document if it's relevant in this case, or they've attested to their signature, taken the oath or acknowledgement. That's when you're signing the notarial certificate and affixing your seal. Got to seal that certificate. Certificate shall be part of or securely attached to the record. I'm going to go back to that in a second. If a notarial act regarding electronic record is performed, the notary may attach an official stamp to or logically associate the stamp with the certificate. The certificate shall be affixed to or logically associated with the electronic record. So when we're talking about the notarial certificate, we're talking about the wording. State of Maryland, county of blank, on this day, so-and-so, blank day, a blank month, a blank year, so-and-so appeared before me and acknowledged this record. That wording is the notarial certificate. It's not a fancy certificate. You don't have to buy them anywhere. The certificate is the wording. The wording makes the certificate. That wording must be securely attached to or a part of a record. There's a bunch of ways to securely attach things to a record. Can't really give you legal advice on the what about this, what about that, what about this, what about that. But think to yourself, did I securely attach that to the record? Is it on the record or a part of the record now? The certificate shall be part of or securely attached to. Right? So if it's not a part of it or securely attached to it before it comes before you, when you complete that certificate, you want to make sure it is now a part of or securely attached to the record that you're notarizing. So don't think of it as some fancy sheet of paper. It's not. The certificate is the wording itself. If you've seen the wording sworn and subscribed to before me, acknowledged before me, signed before me, or attested before me on this blank date, that wording, state of Maryland, county of, with that wording and your signature and seal and title and expiration date, that is the certificate. That's the certificate. So acknowledgements. Making sure I didn't miss a page there. Sorry about bouncing back and forth there for a second. Acknowledgement, first type of notarial act that we're going to talk about here. It's a declaration by an individual before a notarial officer that that individual has signed a record for the purpose stated in that record And if the record is signed in a representative capacity, that the individual that signed the record with the proper authority and signed it as an act of the individual or the entity identified in the record. So this is not swearing to the truth. An acknowledgement is just that they're acknowledging that it's constituting their act or deed, not that they swear to the truth of it. And the signer, right, that person that's appearing before you is the one taking the acknowledgement. So they're the ones making the acknowledgement to you. A good indicator that it's an acknowledgement is that the certificate says the word acknowledged. If your certificate says acknowledged, you're probably doing an acknowledgement. How do you take an acknowledgement? So just a little step-by-step process here of taking an acknowledgement. You're going to start recognizing some of these because they're going to be very common themes over the rest of this presentation. Person making the acknowledgement is personally appearing before the notarial officer, either in person or by communication technology. The notarial officer must properly identify the person requesting the notarial act. You'll notice this is number 3, not number 7. Record the details of the notarial act in your journal. Don't wait till everything is said and done to try to write it in your journal. Once the person's there and you've identified them and you know what it is you're being asked to do as a notary and what it is you're going to notarize and who you're notarizing for, write those details in your journal. Don't wait and forget. Write them in your journal. If something weird happens and you don't end up notarizing the document because you're uncomfortable with something, you decide to deny that notarial act, you already got that information in your journal, right? So that you can remember or fall back on that should you ever have a question about it. But mainly, get the entry in your journal, get it done with. Don't forget it. Don't put it to the side to think about doing it later. Have it in your journal. Always have it in your journal. Every notarization you ever do must be in your journal. Every notarization you do must be in your journal. Last town hall, we talked about what are the requirements for every journal entry. If you're not sure, take a peek at that last town hall on our notary main page on our website. But make that journal entry. If the person has not already signed the document, the record that's going to be notarized, you'll observe the signing of that document. And if the person already signed that document that's going to be acknowledged, then they will just acknowledge to you that they already signed it. The person making the acknowledgement must state to the notary public that the document constitutes their act or deed. Or notary, you can ask the question, right? But you're taking an acknowledgement. They're acknowledging to you that this constitutes their act or deed. Complete and sign that notarial certificate on the record. There are sample acknowledgement certificates in the notary handbook. They are pulled directly from the law itself. And apply that notary stamping device, otherwise referred to as a notary seal, to the notarial certificate that's on or logically associated with or affixed to the record. So, acknowledgements, step by step. Seems too simple, right? It kind of is, right? Kind of is. If you see the word acknowledged in a certificate, that's an acknowledgement. And this is what you're doing every time you see that word acknowledged in a certificate. And if there's not a notarial certificate already a part of that document, you're going to make that notarial certificate a part of or logically associated with or affix it to, securely affix it to the record that's being notarized, the document that's being notarized. So if an acknowledgement is what it is, you notarize the acknowledgement, this is what you're doing. And if there's not a certificate already there and you need to do an acknowledgement because that's what the person's asking for, do that acknowledgement. So verification on oath or affirmation is the next type of notarial act. It's just a declaration made by an individual on oath or affirmation before a notary officer that a statement in the record is true or that a remotely located individual has the identity claim. And we're going to focus on that first part, which is that somebody swearing to the truth of something in that record that's being notarized. So what are we doing on an oath or affirmation? Very similar looking process to the acknowledgement. Still got to personally appear before you, right? You're the notary, they must personally appear before you, either in person or remotely using that communication technology. You must properly identify the person requesting the notarial act. Record those details of the act in your journal. Record them in your journal. Observe the signing of the document. If it's already signed, it's got to be re-signed in front of you for this one. I'll tell you why in a second. Take the individual's spoken statement that the individual swears to or affirms that the contents of the document are true, or whether it's their personal knowledge or knowledge, information, and belief. Generally, just asking if they swear the contents of the document are true. If it's true on their knowledge, information, and belief, the certificate would have that wording in there. Don't see a lot like that, but it might say that wording. Complete and sign the notarial certificate on the record, or affix that certificate to the record, right? Make it a part of or securely attach it to. And then apply your notary seal and make sure that certificate's completed. State of Maryland, county of, wherever you're at, the name or names of the people appearing before you, the date on which they appeared before you. Good way to tell we talked about acknowledgments. The certificate usually says acknowledged. For an oath and an affirmation, it usually says sworn. Somebody's swearing to the truth of something, so it's going to say sworn. Mentioned a minute or so ago that I'll tell you why it has to be signed in front of you. That notarial certificate, if you look at the sample certificates in the book and the certificates in the law, it says sworn and subscribed before me. So they swore to it and subscribed it. They signed it before you, the notary public. So for an oath or affirmation, it's got to be signed before you. They need to swear to it, the truth of it, before you as well. People will often ask, what if they lie? Well, I mean, they're the ones that perjured themselves, right? They took a false oath or affirmation. They said something was true when it wasn't. That's on them. That's not on you. Unless, of course, it's not true, in which case don't let them, you don't want to knowingly let them perjure themselves to you. But, if they're swearing to the truth of it, the notary is not swearing to the truth of it. The individual is swearing to the truth of it. The notary is making sure that that is happening, that right person is doing that. So one other little point of information on this here, it says sworn and subscribed. Again, mentioning the word sworn is a part of that document. And, sample certificates in the handbook, a good sample template certificate of an oath or affirmation is also found in the law. What's the difference between an oath or an affirmation? The affirmation is generally a sworn solemn statement, right? Swearing to the truth of something. An oath is the same thing, but usually referencing a divine being. So oath or affirmation, same legal weight, same thing. Generally speaking, somebody's swearing to the truth of something, and they're telling you they're swearing to the truth of it as well. So witnessing or attesting to a signature. A notarial officer who witnesses or attests to a signature shall determine from personal knowledge or satisfactory evidence that the identity of the individual appearing before the notary has the identity claimed, and they're the ones that signed or is signing that record. This is the certificate that is kind of taking the place, if you remember, notary as official witness under the old, for those who've been a notary for more than 3 years, 3.5 years, that remember the old law, it used to be if there was no notarial certificate, you would not attach one, and you would simply date, sign, and seal, and write your commission expiration date next to the signature of the person you're notarizing for. It's called notary as official witness, was a type of notarial act. This is essentially replacing that, right? You're still witnessing their signature. However, you now need to attach a certificate that says that if one does not already appear for you to complete. This says witnessing or attesting, though, which means that, say somebody brings it to you and it's already signed, they could attest to the fact that they did in fact sign their signature to that document. You're still going to have to identify them, and then have them attest to the fact that they signed it in order to complete the notarial certificate. And in that case, instead of saying witness, the certificate would say attested to or attest before me. But this is the type of notarial act under the new law that is generally replacing the notary as official witness under the old version of the law that changed October 1st, 2020. So witnessing or attesting a signature, noticing a theme here, right, with these numbers, still have to personally appear before you, always, 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 whether it's in person or using that remote technology. Still have to identify the person that's requesting the notarial act. Still need to record the details in your journal. Always, 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 always in your journal. There's never a time, but what if nope, always recording every notarial act in your journal. No matter how well you know them or think you know them or work with them or whatever, every notarial act's going in that journal, and that's why it's listed here every time. We're really trying to drive that point home. Record the details of the journal, the notarial act in your journal. If not already signed by the person executing the record, observe the signing of the document. If the document's already signed by the person executing the record, have the individual attest to the fact that they did sign that record. So that person's either signing that document before you or attesting to the fact that they signed it before you. Complete and sign the notarial certificate on the record. If no certificate is present, attach the certificate for witnessing or attesting a signature. You can find that in the handbook, you can find it directly out of the law itself. So you're affixing that certificate if one does not appear. And if you're just being asked to watch somebody sign, the notary as witness, here you go, right? Witness or attesting a signature. That's what you're doing. And you're going to apply the notary stamping device, or AKA notary seal, on that record. So really a theme here, right? I'm going to bounce back a couple pages. Acknowledgements, 1 through 7. Oath affirmation, 1 through 7. Official witness, 1 through 6. But the point is, every one of these requires personal appearance. Every one of these requires identification. Every one of these requires a journal. Every one of these requires a certificate. Every one of these requires your notary seal to be on there. Every single one of them requires all those things. The certifying or testing a copy of a record. What are we talking about here? A notarial officer who is certifying or attests a copy of a record or an item that was copied shall determine the copy is full, true, and accurate transcription or reproduction of the record or item. So is the notary verifying that that's a true copy per se of some record? Not exactly. Not exactly. But they are verifying that it's a true copy of a record in your possession. The signer's possession when I say your possession. So how do you do a certified copy of a record? Still got to appear in person, right? Same theme there. Still got to identify the person requesting the notarial act. Still need to record this act in your journal each and every time. If the copy of the record was not already created by the person requesting the notarial act, you can observe the copying of the record. You don't have to. You can already have the copy with them. And if the record was already copied, take a look at it in the original and make sure they're a true copy of what's in their possession. You complete and sign the notarial certificate on the record. And if no certificate is present, you're going to affix one. The phrase that pays in that certificate there is that it's a true copy of a record in so-and-so's possession. That so-and-so, that person is the person appearing before you. It's in their possession, right? Folks will often say, can I certify a copy of a driver's license? No. No, and if you want a certified copy of a driver's license, you go to the MVA, birth certificate, you go to vital records, right? Those who can actually certify those documents as true copies. Now, if somebody brings you a copy of whatever it is, could be even one of those things, you're not certifying it's a true copy of that particular item, you're certifying that it's a true copy of something in that individual's possession. And then the next type of notarial act, certified tangible copy of an electronic record. This is exactly as it sounds. We talked about remote notarial acts. Maybe there's an electronic record that's been notarized, and it has to be turned into the tangible record, the paper document. And maybe somebody has to certify that it is a true copy of that electronic record, and the notary is allowed to do that. In this case, the notarial officer is certifying a tangible record, that a tangible record is a copy of an electronic record. They're going to examine that electronic record versus that paper record, make sure it's accurate, reasonably determine that the electronic record is in tamper-evident format, personally print or supervise the printing of that electronic record onto the paper or other tangible medium before they go affix their seal. Thinking of scenarios in which this might come up, maybe something's been remotely notarized and you need to go back to that notary and say, hey, I need a certified copy of that electronic record in tangible form, and they could go back and print that electronic record and to make it to a tangible record, i.e. paper record, and then affix the seal to certify, I'd say, true copy, a tangible copy of the electronic record. Steps, same three, right? 1 through 3. Consistency. Person's got to appear before you. Have to identify that person requesting the act. Have to record it in your journal each and every time. Notary must reasonably determine whether the electronic record is in tamper-evident format before everybody kind of freaks out and worries about what is it? Oh my God, what do I got? How do I know that? If you're a notary performing remote notarial acts for electronic records, you have to use one of the RON vendors that's authorized by us. And if they're authorized by us, then they are meeting this requirement. They have to meet that requirement in order to gain authorization for use during remote notarial acts on electronic records. So those authorized RON vendors meet that requirement. So if you're doing remote notarizations and somebody needs a tangible copy of the electronic record and they need you to notarize it's a true copy, then if you're using an authorized RON vendor to do that, you're good. It's in a tamper-evident format. So you're going to personally print or supervise the printing of the electronic record. Print it on, print it from your computer or your phone to your printer. Complete and sign the notarial certificate on the tangible record. And if no certificate is present on the record, you affix it, sample certificate in the handbook again, and apply your notary seal to the certificate on or affixed or logically associated with that record. So you'd be notarizing as, stating basically that the tangible record is a true copy of the electronic record. And that's what you'd be notarizing in this scenario. So we've done acknowledgement, we've done oath or affirmation, we've done witness or attest, we've done certified copy, we've done certified copy of a electronic record. Last, a notarial act here that we're going to talk about, protest of a negotiable instrument. The notary must take a protest in the form prescribed by the comptroller. That's actually being done away with effective June 1st, or effective July 1st, I'm sorry. And so it will not have to be in a form prescribed by the comptroller anymore. And but really, negotiable instruments protests are mostly covered in commercial law. And if you read that definition there, a protest is a certificate of dishonor made by United States consul or vice consul or notary public or other person authorized to administer oaths by law in the place where the dishonor occurs. So if you go on to read this definition here, at the end of the day, if you're a notary, you might want to seek private legal counsel for protest. It's covered in commercial law. We can't give advice on how these things should look or in what form they should be, but the law does go into some detail here in commercial law article about what a protest is and what it's being done for. And, you know, the important takeaway here is it's either drawn to or payable outside, or payable to something outside the United States and its territories in DC. So protests are not something you should be doing for something that's happening within the confines of the United States or its territories or DC. Matters regarding negotiable instruments are found in the commercial law article. There's the sections. So a little bit of a review here for all this, and I know I threw a lot of information out there about the types of notarial acts and certificates. Certificates required for every notarial act that a notary public performs. Every act requires a certificate. An oath or affirmation is the declaration made by an individual that the statement in the record is true. Or if you're having somebody swear to the identity of somebody remotely, that remotely located individual has the identity claimed. If you're witnessing or attesting a signature, you're determining that the individual that appeared before you is actually the person that signed the record. To identify them, you make sure that's their signature on that record. Acknowledgements, it's not an oath or affirmation, right? So it's not a statement of truth. It's just that somebody signed that record, that document, for the purpose stated in that record. You can certify copies of stuff in someone's possession as a true copy of something in their possession. You can certify that a tangible copy of something is the true copy of the electronic record. So these are the things you're doing on a regular basis. The main notarial acts that you'd see on a regular basis are acknowledgement, oath/affirmation, and witness/attest to signature. Those are your big three. That's what you're going to see the vast majority of the time you notarize. Just from our, my own personal experience and seeing things over the many years I've been here, it's usually one of them three, usually. And so for certificates, they're always on there, right? You're always attaching a certificate. If there's not one already present on the record that's being notarized, if there's already a certificate on there, great, right? You just complete the certificate. If there's not, you affix the certificate. Again, you want to really go to the law and the handbook for samples of their certificates. People will inevitably ask, can I just make my own? Yeah, yep. Yes, you can, right? Because it's the wording. It's the wording that makes it the certificate. Not a formal document you must purchase. That's not what it is. It's the wording that makes it the certificate. So you can create your own out of those templates of the handbook if you like. So just trying to get ahead of one of the potential questions there that we usually get asked about this type of topic. But the certificate, it's the wording, right? It's the sworn and subscribed before me. State of Maryland, county of, wherever you are at. Who appeared before you? What day did they appear before you? Did they take an acknowledgement or an oath or affirmation or witness, or did you just witness or attest their signature? They attest their signature, right? What are you doing as a notary? That's the story the certificate tells. And if you know your types of notarial acts, if you know what type of notarial act is being requested of you, then you'll know what your role is. You'll know what certificate to attach if there is none present. If there's one present, you'll know exactly what it is you're doing. Right? So that's the important part. What are we actually doing as a notary here? It's important to know to identify people and watch them sign, generally speaking, of course. It's important to keep the journal, of course. You saw all those points outlined here for every type of notarial act. But you really kind of want to know, if I'm doing something and I've got a commission to do something as an officer of the state of Maryland, know those types of notarial acts and what they are. And this is a good summary of what they are here on this town hall. And, for those of you that are kind of maybe your head spinning, that was a lot of information at one time, go back and kind of rewatch this thing a little bit here. If you're unsure about the types of notarial acts and what they are, let that sink in. The handbook's a good guide. Those of you who've taken the courses of study that are authorized, they all cover this. Pay attention in those sections. Don't just kind of glaze through when you're renewing. Pay attention. If you've been a notary a long time, that law is very different from when you started. Even if you became a notary 4 years ago, the law that you got approved to be a notary for is totally different now, and you need to know that and be aware of it. You needed to know that back when it changed, right? So pay attention in that course of study. It's going to cover all these certificates, and it's going to cover them in a little more detail about what they all are. And it's important to know what they are, because if they're not on the document itself, you're going to need to know what to affix. And we can't really give you advice on what to affix. It's really based on what that person asks, right? They just asking for you to notarize their signature as a witness. There you go, witness or attest, right? They swearing to the truth of something. Is that what they're telling you? That's oath affirmation, right? Or are they just saying something that's confirming that they're doing something, acknowledging that they're doing something? That's the acknowledge. So you're paying attention to that request to help you determine what, if there's not already a certificate there, what should be attached. So if there's already a certificate there, then that's the one you're using. So contact information, I promise you we get back to the contact information here. And dlnotary_SOS@maryland.gov, dlnotary_SOS@maryland.gov. That 410-974-5521 is the main office phone number. Ask for the Notary Division. You could also call 410-974-5520. That's right into the Notary Division phone line itself. So 5521 or 5520, and dlnotary_SOS@maryland.gov. This is where you want to ask your questions to. We get a lot of emails to the town hall inbox as well with questions about all kinds of general notary stuff. Town hall inbox, it's meant for kind of emails specific to these town halls about what the schedule is, or how do I do this or that with regards to the town hall. If you want a notary question answered, contact this phone number or this email address. We're pretty quick about responding to those, and we're pretty quick about calling back if we miss your call. So usually within a day, oftentimes the same day, but usually within one business day. By the next day, you've gotten an answer from us. You've gotten a call back at the very least, or an email back with whatever the answer is, or maybe we don't have the answer right up front. We just write back and let you know that and get back in touch with you when we have it. But either way, you should be responded to pretty quickly when you contact the Notary Division. They're very good about that. Our notary officers are fantastic. Carrie Ann, Marquita, Bree, all of them, fantastic job in taking care of the customers and answering those questions. You don't always maybe love our answer, but it's the answer, and we do our best to get it to you in a timely manner. So quick shout out to them on that. Before we go to questions and answers, just kind of want to do a little housekeeping again and summarize real quick. Town hall here is recorded. It is going to get posted online, usually within a few days, but definitely within the next week. It'll be online. This recording, presentation, content, it's for informational purposes only. It's not intended to be legal advice. And in a few minutes here, we're going to take some of these questions in the chat. We're going to talk to some of you if you have something you need to talk about. And like I said, try to keep them relevant to this topic here that we've covered and stuff in this town hall. If you have general notary questions, reach out to us there offline, DL Notary email address or the phone number, and go through those. We really want to focus on the people that have questions about this information on this town hall. And really just want to thank everybody for your interest in the topic and for joining us today. Glad that you take pride in what you're doing and care to spend a little time with us and learn a little more, or hopefully refresh some of what you already know. And also thank you for your service. You're an officer of the state of Maryland. Notary Public is an officer of the state of Maryland. And, you serve an important function in society as a notary public. And, it's very important that you know your job and do it well and do it right. And, just thanks for joining us today and in your quest to do that. Obviously, you're here, and we really appreciate you being here to further that cause and that purpose. So we'll end this recording here. Thanks again, everybody. And again, it'll be posted online, and on behalf of the secretary and deputy secretary and everybody here at the Secretary of State's office, thank you very much.
Can I ask a question, Mr. White?